You're a joke. Judge Sullivan's voice boomed across the Boston courtroom, his finger pointing accusingly at Sarah Mitchell. The unassuming woman in her navy cardigan stood silently, eyes downcast as lawyers snickered. Little did they know, beneath her modest appearance lay the mind of a former legal prodigy. When the gavel struck again, Sarah raised her head, opened her worn leather portfolio, and said 6 words that froze the blood of every attorney present. Your Honor, I'd like to present Exhibit C. What happened next left the entire courthouse speechless and changed Massachusetts property law forever. The morning sun filtered through the faded curtains of Sarah Mitchell's kitchen in Boston's historic Oak Ridge neighborhood. At 36, she moved with quiet purpose, preparing her morning coffee in the modest 2-story home that had belonged to her grandmother and her great-grandmother before that. The house wasn't fancy, worn wooden floors, walls that needed fresh paint, and furniture that told stories of generations. But it was home. Sarah smoothed down her simple navy cardigan and checked her reflection in the small mirror by the door. Her chestnut hair was neatly pulled back in a practical bun, her face free of makeup. She looked nothing like the sharp-suited attorney she'd been 5 years ago at Harrington & Walsh, one of Boston's most prestigious law firms. Just another day, she whispered to herself. A ritual that had carried her through the hardest times. The certified letter had arrived 3 months ago. Meridian Development Corporation wanted her house and 19 others on her street to build luxury condominiums. The letter offered what they called fair market value, a sum that reflected nothing of the home's true worth to Sarah or her community. While her neighbors panicked, many already signing away their properties, Sarah had quietly begun her research. The development company had powerful connections, including Judge Sullivan, who would oversee her case today. But Sarah had something they didn't expect: the truth. She picked up the worn leather portfolio from her kitchen table. Inside were documents she'd spent weeks gathering from county records, historical archives, and her own family's papers. Papers that told a different story about Oak Ridge than the one Meridian Development was selling. Her phone buzzed. A text from Mrs. Parker next door. "We're all praying for you, honey. Stand strong." Sarah smiled. At 84, Mrs. Parker had lived in Oak Ridge her entire life. Her house was already in escrow with Meridian, but she still believed Sarah might save the neighborhood. Walking onto her porch, Sarah surveyed the street she loved. Mr. Coleman watering his prized dahlias, the Martinez kids racing to catch the school bus. And across the way, the community garden she'd helped establish after leaving her law career behind. This modest life wasn't what she planned when she graduated top of her class from Harvard Law, but it had given her something her former career never could: purpose. As she walked toward the bus stop, a sleek black SUV slowed beside her. The window rolled down, revealing James Harrington himself, silver-haired partner of her former firm. "Sarah," he called. "It's not too late to accept their offer. You're fighting a losing battle." Sarah nodded politely. "We'll see about that, Mr. Harrington. Have a good day." As the SUV pulled away, Sarah gripped her portfolio tighter. They thought she was just a simple woman fighting progress. They had no idea what was coming. The Suffolk County Courthouse loomed large against the Boston skyline, its stone columns and grand steps designed to intimidate. Sarah had once climbed those steps with confidence, designer briefcase in hand. Today, she clutched her worn leather portfolio and took a deep breath before ascending. Inside, the marble lobby echoed with important footsteps. Attorneys in $1,000 suits huddled with clients, speaking in hushed, assured tones. Sarah found a quiet bench and reviewed her notes one last time. Her case was simple. Oak Ridge qualified for historic preservation under a little-known amendment to Massachusetts Property Conservation Act of 1997. "Well, look who it is." A familiar voice drew Sarah's attention. She looked up to see Vanessa Thornton, junior partner at Harrington & Walsh. They'd started at the firm together, shared late nights preparing cases, celebrated each other's wins. That was before. "Hello, Vanessa," Sarah said calmly. Vanessa's eyes swept over Sarah's simple clothes, her lack of makeup, the scuffed shoes. "I heard you were representing yourself. Couldn't afford an attorney on," she paused. "Whatever it is you do now." "I grow vegetables and teach community law workshops," Sarah said, standing to meet Vanessa's gaze. "And I know enough to represent myself." Vanessa laughed, pearl earrings catching the light. "Sarah, be reasonable. You're up against our entire legal team and Judge Sullivan, who, between us, plays golf with Mr. Meridian every Sunday." She lowered her voice to a conspiratorial whisper. "The development is already approved. Today is just a formality." "Then I suppose you have nothing to worry about," Sarah replied. Vanessa's smile faltered slightly. "Look, for old time's sake, take the offer. It's generous. It's not about the money." "It's always about the money," Vanessa said, her professional mask slipping momentarily. "Why else would you throw away a partnership track to live like this?" Before Sarah could respond, the courtroom doors opened. The bailiff called out, "All parties in Meridian Development versus Mitchell and other respondents, please proceed to Courtroom C." As they entered the imposing courtroom, Sarah noticed the 5-person legal team from Harrington and Walsh arranging themselves at the plaintiff's table like chess pieces. Behind them sat an older man with silver hair and cold eyes, Edward Meridian himself. Judge Sullivan was already seated, reviewing papers with a frown that deepened when Sarah entered. She'd never appeared in his courtroom during her time at the firm, but she knew his reputation: efficient, impatient, and known for favoring development over preservation. Sarah found her place at the defendant's table, arranging her documents with methodical care. The other neighborhood residents huddled nervously in the gallery behind her. She caught Mrs. Parker's encouraging nod, Mr. Coleman's worried smile. As the proceedings began, Sarah's mind drifted back to the night 3 months ago, when her journey to this moment truly began. The community meeting at Oak Ridge Methodist Church had been packed with anxious homeowners, many already clutching Meridian settlement checks. "They're saying we don't have a choice," Mrs. Martinez had said, her voice trembling. "That eminent domain gives them the right." Sarah had listened, blood boiling, as the Meridian representative, a young man in an expensive suit, explained how progress couldn't be stopped, but they were being more than generous. That night, after everyone had gone home, Sarah had sat alone in her grandmother's study, surrounded by family photo albums and faded newspaper clippings. Her grandmother, Eleanor Mitchell, had been a community historian, meticulously documenting Oak Ridge's rich past as one of Boston's oldest historically black neighborhoods, established by formerly enslaved people after the Civil War. "The truth is in the details, Sarah," her grandmother always said. And so Sarah had begun to dig. For weeks, she'd spent every spare moment at the Boston Historical Society, the County Records Office, and the Massachusetts State Archives. She'd taken personal days from her part-time job at the community garden to travel to the state capitol, searching for the legislative records of the 1997 Property Act. What she discovered, buried in subsection 43 bits of the amendment, was extraordinary. Properties with documented historical significance to marginalized communities were eligible for special preservation status, requiring additional review beyond standard eminent domain proceedings. The provision had never been successfully invoked, likely because few people knew it existed. It had been added by a retiring black state senator as a last act before leaving office, tucked into a larger bill primarily concerned with commercial zoning. Sarah still remembered the moment she found it, sitting in a dusty corner of the state archives. Her hands had trembled as she photocopied the relevant sections. But documentation of the law was only half the battle. She also needed to prove Oak Ridge's historical significance beyond dispute. That search led her to interview community elders, unearth church records, and spend countless hours cross-referencing census data. The breakthrough came when she discovered her own great-grandmother's journal in a box in the attic. Amelia Mitchell had been a civil rights activist in the 1960s, and her house, Sarah's house, had served as an unofficial meeting place for organizers during the Boston sit-ins. Amelia's journal contained not only her personal accounts, but also letters from prominent civil rights leaders thanking her for providing a safe haven in Oak Ridge. These documents, combined with photographs and newspaper clippings, created an undeniable record of historical significance. Sarah had compiled everything meticulously into what became her leather portfolio, creating 3 distinct exhibits: the legal basis for preservation, Exhibit A; the documented historical significance of Oak Ridge, Exhibit B; and the evidence of her own home's particular importance to civil rights history, Exhibit C. What she hadn't included in her filing documents, what she'd saved for this very day, was the bombshell in Exhibit C. A photograph showing a young Edward Meridian among counter-protesters opposing integration, standing on the very street he now sought to demolish. All rise for the Honorable Judge William Sullivan. The courtroom fell silent as Judge Sullivan took his seat, his expression already set in what Sarah recognized as his business face. He shuffled papers, adjusted his glasses, and then looked up, eyes scanning the room before settling first on the Harrington and Walsh team, then with noticeably less warmth on Sarah. In the matter of Meridian Development Corporation versus Mitchell et al., I see we have counsel for the plaintiff. He nodded toward the impressive row of attorneys. And Ms. Mitchell is representing herself. His tone made the question sound like an accusation. Yes, Your Honor, Sarah replied, standing with perfect posture. Pro se representation. James Harrington rose smoothly. Your Honor, before we begin, we'd like to note that we've made multiple generous settlement offers to the remaining defendants. We believe today's proceedings are unnecessary and a waste of the court's valuable time. Judge Sullivan nodded sympathetically. So noted, Mr. Harrington. Ms. Mitchell, are you aware that you're facing one of the state's premier legal teams in a matter that has already been approved by the City Planning Commission? Sarah remained steady. I am, Your Honor, however. And you still believe you can adequately represent not only yourself, but essentially the interests of an entire neighborhood. The judge interrupted, his voice carrying a hint of mockery. A few chuckles rose from the plaintiff's table. Sarah ignored them. I'm prepared to present evidence regarding the historical significance of Oak Ridge under subsection 43 bits of the Massachusetts Property Conservation Act amendments of 1997, which would exempt. Judge Sullivan waved his hand dismissively. Yes, I've reviewed your filing, Ms. Mitchell. While I appreciate your... He paused, searching for a word. Enthusiasm, this court has limited time. Sarah tried again. Your Honor, if you'd look at Exhibit A in my filing. Ms. Mitchell, the judge's voice sharpened. This isn't a classroom where you can lecture us on obscure legal theories you've discovered in your... His eyes fell to her worn portfolio. Research. The courtroom grew uncomfortably quiet. Vanessa Thornton smirked, whispering something to a colleague who poorly suppressed a laugh. Judge Sullivan leaned forward, his finger pointing directly at Sarah. His voice rose, filling the courtroom. You're a joke, playing lawyer when real people's livelihoods and the future of Boston are at stake. This development will bring jobs, tax revenue, and progress to an area that desperately needs it. Sarah stood perfectly still, absorbing the verbal assault. Your Honor, James Harrington interjected smoothly. Perhaps we could move for summary judgment. I'm inclined to agree, Judge Sullivan replied. Unless there's some miraculous evidence, Ms. Mitchell has been hiding. Sarah raised her head slowly. Actually, Your Honor, I'd like to present Exhibit C. The bailiff carried Sarah's Exhibit T to Judge Sullivan, who took it with visible reluctance. The large courtroom remained perfectly silent, the tension palpable as the judge's eyebrows furrowed while examining the contents. Your Honor, Sarah said, her voice stronger now. Subsection 43 bits of the 1997 Property Conservation Act Amendment specifically states that properties with documented historical significance to marginalized communities require special preservation review before eminent domain proceedings may be finalized. Judge Sullivan looked up, annoyance warring with confusion on his face. Ms. Mitchell, I'm familiar with the Property Act. With respect, Your Honor, few people are familiar with subsection 43 bits, Sarah countered, stepping out from behind her table. It was added by Senator James Thompson just before his retirement and has never been successfully invoked in court. James Harrington rose quickly. Your Honor, this is absurd. If such a provision existed, our legal team would be aware of it. Sarah didn't miss a beat. Page 312 of the amendment, paragraph 3, lines 15 to 29, she recited from memory. I've provided the full text in Exhibit A, along with the legislative history and Senator Thompson's floor speech explaining its intent. Judge Sullivan shuffled through her previously filed documents with growing unease. Finding the section, his eyes widened slightly before he controlled his expression. Even if this provision exists, Ms. Mitchell, you would need to prove substantial historical significance. Which I have done, Your Honor, in Exhibits B and C, Sarah replied, her confidence building. Oak Ridge is one of Boston's oldest historically black neighborhoods, established by formerly enslaved people after the Civil War. During the Civil Rights Movement, it served as a crucial organizing center. She gestured to the photographs in Exhibit C, my own great-grandmother's home, which Meridian Development plans to demolish, hosted planning meetings for sit-ins and voter registration drives. I have letters from civil rights leaders confirming this, along with newspaper documentation. Furthermore, Sarah continued, there's a matter of personal interest that Mr. Meridian may have failed to disclose. Edward Meridian shifted uncomfortably in his seat as Sarah pointed to a specific photograph in the exhibit. This photograph from May 1964 shows a demonstration on Tremont Street. In the counter-protest group, third from the left, is Edward Meridian himself, holding a sign opposing integration, on the very street where my great-grandmother was hosting civil rights organizers. A collective gasp rippled through the courtroom. Judge Sullivan's face reddened as he studied the photograph. Your Honor, Sarah pressed her advantage. This creates a clear conflict of interest that Mr. Meridian failed to disclose during the Planning Commission hearings. According to Boston Municipal Code Section 28-7, such conflicts must be stated on the record before development approvals. James Harrington was on his feet instantly. Objection. This is outrageous and irrelevant. It is entirely relevant, Sarah countered, switching effortlessly into the authoritative courtroom voice she hadn't used in 5 years. Mr. Meridian's personal history with this neighborhood raises questions about his motivations. She turned to face the judge directly. Your Honor, based on subsection 43 bits and the documented historical significance I've presented, I move that the eminent domain proceedings be suspended pending a full historical preservation review, as required by state law. Judge Sullivan's face had transformed from mockery to guarded respect. He glanced at the Harrington and Walsh team, now huddled in urgent whispers. Ms. Mitchell, he said, his tone markedly different. Where exactly did you acquire your legal knowledge? Sarah met his gaze steadily. Harvard Law School, Your Honor. I graduated first in my class before spending 4 years at Harrington and Walsh. Judge Sullivan blinked, momentarily at a loss for words. James Harrington cleared his throat, glancing uncomfortably at Edward Meridian, whose face had lost its color. Ms. Mitchell worked at our firm several years ago, Harrington confirmed reluctantly. She was quite promising. More than promising, Sarah corrected calmly. I was on partnership track, handling major cases including the Cambridge preservation dispute that bears significant similarities to this one. The shift in the room was palpable. What had begun as a seemingly one-sided case had become something else entirely. Judge Sullivan studied Sarah with new eyes, his earlier condescension replaced by cautious respect. If you were such a promising attorney, Ms. Mitchell, why did you leave the profession? He asked, genuine curiosity in his voice. Sarah took a deep breath. 5 years ago, Your Honor, I was assigned to represent a development corporation much like Meridian. They wanted to demolish a historic black church in Roxbury to build luxury apartments. She paused, the memory still painful. During discovery, I found documents proving the church qualified for historical preservation. When I brought this to Mr. Harrington's attention, she glanced toward her former mentor. I was told to bury it. When I refused, I was removed from the case. James Harrington's face darkened. Your Honor, this is hardly the venue. The church was demolished 2 months later. Sarah continued, her voice steady. I couldn't be part of a system that would willingly erase our history for profit, so I resigned. A murmur swept through the gallery. Judge Sullivan sat back, absorbing this information. Edward Meridian leaned forward to whisper urgently to his legal team. Vanessa Thornton's face had gone pale as she furiously scribbled notes. Your Honor, Sarah said, reclaiming the moment. I may have left the legal profession, but I never stopped believing in justice. The law is clear. Subsection 43 bits requires additional review for historically significant properties. Oakridge qualifies. The judge nodded slowly, then turned to the Harrington and Walsh team. Counsel, your response to Ms. Mitchell's motion. James Harrington stood, visibly regrouping. Your Honor, while Ms. Mitchell's historical research is interesting, we maintain that the city's eminent domain authority supersedes any obscure subsection. Sarah smiled slightly. Your Honor, if Mr. Harrington questions their authenticity, I've brought the originals, verified by the Massachusetts Historical Society, just last week. Judge Sullivan raised his hand. That won't be necessary just yet. He paused, studying Sarah thoughtfully. It seems I may have underestimated you, Ms. Mitchell. Many people do, Your Honor, Sarah replied quietly. It's an advantage I've learned to use wisely. After a 15-minute recess to review the evidence, Judge Sullivan returned to the bench with a composure markedly different from his earlier demeanor. The gallery had grown, word having spread through the courthouse about the unexpected drama unfolding in Courtroom C. Having reviewed the evidence presented by Ms. Mitchell, I find that subsection 43 bits of the 1997 Property Conservation Act amendment does indeed apply to this case. The historical significance of Oakridge has been substantively documented. Sarah maintained her composure, though her heart raced. Behind her, she heard Mrs. Parker's soft, "Praise the Lord." Furthermore, the judge continued, I find Mr. Meridian's undisclosed personal history with the neighborhood constitutes a conflict of interest that should have been declared during initial proceedings. Edward Meridian's face darkened with anger, but he remained silent as his lawyers exchanged worried glances. Therefore, I am issuing an immediate stay on all eminent domain proceedings related to the Oakridge properties, pending a full historical preservation review as required by state law. The gavel struck with finality. Sarah closed her eyes briefly, relief washing through her. Ms. Mitchell, Judge Sullivan added, I owe you an apology for my earlier remarks. You've represented yourself and your community with exceptional skill and thoroughness. Thank you, Your Honor, Sarah replied. As the courtroom erupted in excited conversation, Sarah turned to her neighbors. Mrs. Parker embraced her, tears streaming down her lined face. Mr. Coleman pumped her hand enthusiastically. You did it, child. You really did it. From the plaintiff's table, James Harrington approached, his expression complex. Impressive work, Sarah, he said stiffly. Though this is only a temporary setback, we'll appeal. Sarah nodded. I know, and I'll be ready. Beyond Harrington, she saw Edward Meridian storming out, refusing to look at anyone. The battle wasn't over, but the first victory. proving that the law could protect communities when wielded by those who truly understood it, belonged to Sarah and Oak Ridge. 1 year later, Sarah stood in her garden harvesting tomatoes as the afternoon sun warmed her shoulders. The historic preservation designation for Oak Ridge had been finalized 6 months ago after a thorough review that acknowledged the neighborhood's vital role in Boston's civil rights history. Meridian Development had eventually withdrawn their appeal, redirecting their project to an already commercialized area nearby. More importantly, 3 other historically black neighborhoods had successfully invoked subsection 43 bits to protect their own communities. Sarah's simple wooden gate creaked open. Vanessa Thornton stepped into the garden, looking distinctly different in jeans and a casual blouse. "The legal clinic's getting busy," she said, accepting a tomato from Sarah with a smile. 2 more neighborhoods need consultation. After the trial, Vanessa had left Harrington and Walsh, joining Sarah to establish the Oak Ridge Community Law Project. Together, they offered pro bono services to vulnerable communities facing similar battles. "We'll help them," Sarah said, brushing soil from her hands. She looked down the street where children played hopscotch on sidewalks that had once hosted civil rights leaders. Mrs. Parker waved regally from her porch. Some still saw Sarah as just a simple woman in a navy cardigan. But Sarah knew that sometimes, in the right hands, simplicity was its own kind of power.